Right, good morning, everyone. Thank you for taking the time to attend today's webinar. I will be going through this topic of key clauses to look out for in PSS contract administration in a post-COVID-19 world. So next slide, please. Some of the key topics that I will be running through today would be 8 key topics. We will be dealing with variations and procedural requirements, variations in substantive requirements, extension of time, loss and expense, termination, final completion, liquidated damages, and service methods. So these key 8 topics are topics that are frequently recurring during this COVID-19 phase, and I think it will be a great opportunity to share some of my insights on these topics with all of you today. Next slide, please. So very quickly, we will dive right in to variations and procedural requirements. Now, it's very often overlooked that in terms of claiming for variations, that you have to comply with procedural requirements. So the first set of procedural requirements that we'll be looking at today will be clause 2.5 of the PSSCOC. I will be referring to the 2020 version, which has just been amended. So clause 2.5, typically the instructions that are given by the SO, the superintending officer, will be in writing. Now, if it's not in writing, then typically the SO will provide a confirmation, a written confirmation of his oral instruction in writing. And if he doesn't do so, then the contractor will have 3 working days to actually confirm in writing to the SO any oral instruction. And if such confirmation is not contradicted in writing within the next 3 working days by the SO, it shall be deemed an instruction of the SO. Now, what is interesting here in the PSSCOC 2020 version is that if the SO were to withdraw any such oral instructions at any time during the 6 working days, then the SO may certify loss and expense during that period of time if the contractor has incurred such a loss and expense by virtue of complying with the SO's oral instruction and by virtue of the fact that the oral instruction has been withdrawn. The PSSCOC 2020 version also clarifies that the term working days shall exclude Sundays and public holidays. Next. Now I come to the second very important clause. Again, this is another often overlooked requirement in the contract. So clause 19.2 essentially provides that an instruction in writing is typically would clarify that it is a variation. Now, if it doesn't state that it is a variation, but it simply tells the contractor to do a particular set of works, then what the contractor can do is to, within 14 days from the date of receipt of the written instruction, notify in writing the SO. And what the SO may do within the next 14 days would be to notify, confirm, modify, rescind, or contradict in writing the instruction. And then the contractor can then comply with that instruction. Next. The third very important procedural requirement, and this is extremely important because it is a condition precedent. So clause 23.1 provides that the contractor must give notice in writing of his intention to claim for variations. And this must be done within 60 days after the event giving rise to his claim has first arisen. The provision also very clearly states that the notice shall specify the event and its consequences, and the giving of such a notice shall be a condition precedent to any entitlement that the contractor may have. Now, this is a provision that many contractors tend to overlook. And when it comes to claims, whether it's in adjudication, litigation, or arbitration, very often the employer or the main contractor will put up a defense of you haven't complied and hence you are barred from claiming the particular set of variations. And then to get around this issue, you will then have to argue a waiver or the fact that there is an implied promise to pay, that line of argument. So to avoid any complexity with the proceedings in terms of claiming for variations, it's very important that contractors should comply with clause 23.1 of the PSSCOC. Next. So some of my observations about these three important procedural requirements. The first is that you will note that in the PSSCOC 2020 version, what has happened is that the contractor will now be required under clause 2.5 to confirm oral instructions in writing within 3 working days. Now, this is down from 7 working days under the PSSCOC 2014 version. And similarly, the SO will have to contradict any such confirmation from the contractor also within 3 working days and is down from 7 working days. Now, if the SO, as I mentioned earlier, withdraws his or her oral instructions within 6 working days, then the SO may certify loss and expense claims incurred by reason of the contractor's compliance with the withdrawn oral instruction. As I also mentioned earlier, working days has now been clarified to exclude Sundays and public holiday. So overall, you will see that under the new PSSCOC 2020 version, the timeline for confirming oral instructions has been shortened, is to encourage expeditious dealing with all these variations, and the contractor can also claim loss and expense for any withdrawn instructions if it's certified by the SO. Next. For clause 19 and clause 23 that we looked at earlier, there's no change to the process. What that means is that if you are looking to actually claim for a variation during this period of time, you will still have to comply with the requirements in clause 19, i.e. clarify which category of instructions, written instructions, the set of work belongs to, and you will also have to make sure that you comply with the condition precedent in clause 23 of the PSSCOC. Next. Now I come to the other very important subtopic of variations in the substantive requirements. This set of requirements is often raised during this period of time because many people would want to know whether they are entitled to claim variations for the increased costs, perhaps as a result of COVID-19. So now let's look at clause 19.1 carefully. Clause 19.1 deals with the substantive requirements on when you can claim for variation. It is a very widely worded clause. You will see that variations pertain to subsections A to F, any increase or decrease in the quantity of the part of the works, addition or omission from the works, a change in the character, quality, or nature of any part of the works, a change in the levels, lines, positions, and dimensions of any part of the works, demolition of or removal of any part of the works no longer desired by the employer or the SO, or requirement to complete the works or any phase or part of the works earlier than the relevant time for completion. So in summary, variation is very, very broadly worded in this particular provision. So how does that interact with the COVID-19 works then? Next. The important provision in PSSCOC would be clause 7.1 if you're trying to claim for variations pursuant to any COVID-19 related impacts. Because you will see in clause 7.1 that the contractor shall comply with and give notices required by any law, regulation, or bylaw, or by any public authority or public service company. So this particular provision could potentially allow you to claim for variations if you have to comply with, say, for example, MOM requirements or any circuit breaker requirements in the last few months. And clause 7.2 then clarifies that this particular variation would have to arise out of an event that is not reasonably foreseen by an experienced contractor at the time of submission of the tender, and if it is not required by or in consequence of any deficiency, fault in the design of any part of the works for which the contractor is responsible for. Next. Some observations here. You will see that generally clause 19 of the PSSCOC, if you read that together with some of the earlier procedural requirements that we've looked at, a variation generally is a change in design works. And works here include temporary works. There is no variation as long as the SO does not issue any VOs, because you may recall that there are procedural requirements. And the one exception to get you out of this set of variations would be if under clause 7.2 PSSCOC, you argue that you are complying with the law, regulation, notices by public authority. And you have to show that because you're complying with works that could not reasonably have been foreseen by an experienced contractor at the time of tender, probably due to COVID-19, then you will be entitled to claim under this particular provision. Next. I now come to the third category, and an important one that is on most people's mind, and that pertains to extension of time. Now, for extension of time, let's look closely at clause 14.2 of the PSSCOC 2020 version. You will see here that time may be extended for your works if, notwithstanding due diligence and taking of all reasonable steps by the contractor to avoid or reduce such delay, it has been caused by any of the following events. So what I've done here is I've picked out a number of potential grounds in which a contractor could rely on in seeking extension of time if your works are affected by a COVID-19 event. So A, we have here an event which is beyond the contractor's reasonable control, i.e. a force majeure event. C here, potentially embargoes in Singapore. E here, we have requirements of law, compliance with requirements of law, regulation, or public authority as stipulated in clause 7.1 that we've looked at earlier. Or Q, epidemics or pandemics resulting in shortages of the labor, goods, materials, or construction equipment required for the works, or inability to proceed with any part of the works. Next, please. Again, some observations. You will see that the PSSCOC 2014, unlike the one that we've just looked at, listed force majeure as a ground for extension of time. But force majeure in the 2014 version is undefined. And what has changed in the PSSCOC 2020 version is that it has clarified that force majeure is now an event which is beyond the contractor's reasonable control. And what the new version of the PSSCOC has done is that it has also added epidemics and pandemics as grounds for extension of time. And these grounds, you will see that the threshold is quite low as long as you show that there are certain shortages or an inability to proceed with any part of the works, then you will be entitled to extension of time. So this is a very wide and broad ground which covers almost every consequence. And under the PSSCOC, COVID-19 and similar events would clearly entitle the contractor to an EOT. Now, the problem though is that many contracts at this point in time are still based on the PSSCOC 2014 version. So it remains to be seen how the amendments will affect the interpretation of the EOT clause for current projects. Next, please. So let's have a look. If you compare the PSSCOC 2020 version to the old PSSCOC 2014 version, which I believe most of you are currently using, then you will have to check, is your event one that is still persisting despite taking all reasonable steps by the contractor to avoid or reduce the same? And you will have to show that it is an event that is affected by force majeure. So force majeure, as you may recall under the 2014 version, is not defined. So what you will have to show is you will have to borrow the definition from common law and show that it is an event that is unforeseeable and which have prevented performance of the relevant obligation. So the key word here is prevented performance of the relevant obligation, and not merely made the obligation more onerous. So if it's just more difficult or more expensive to do so, it may not be a force majeure event. And then, of course, you are still entitled to argue C, embargoes in Singapore, and you have E, compliance with requirements of law, regulation, or public authority or public service company as stipulated in clause 7.1 of the PSSCOC. So you will see that in contrast to the new PSSCOC 2020 version, the old version of the PSSCOC is much more limiting. It's arguably more difficult to raise a COVID-19 event as a potential ground for EOT unless you can fall within one or more of these grounds that I've shown on the screen. Next slide, please. Loss and expense. This is another big topic that weighing on most contractors' minds. Can I claim loss and expense if my works are affected by COVID-19? So again, clause 22.1 sets forth several requirements before a contractor can claim for loss and expense. And the keywords, I've underlined them. They are, you will have to show that any phase or part of the works have been disrupted, prolonged, or otherwise materially affected by A, issue of an instruction for a variation, B, issue of an instruction in relation to a provisional sum item, C, failure of the employer to give possession of the site, D, suspension of the SO by the SO of any work for a cause, E, the contractor not having received from the SO within a reasonable time necessary drawings, instructions, or other information. Next slide, please. Or you have instruction by the SO under any of these clauses 3.6, 4.4, 10.4, 10.6, etc. Unforeseeable adverse physical conditions, acts or omissions of other contractors engaged by the employer, or any act of prevention or breach of the contract by the employer. Next slide, please. Some observations here. What has changed in the PSSCOC 2020 version is that now the definition of loss and expense has been widened to include construction equipment as a direct relevant cost. So that's good news, because now it's quite clear that construction equipment would be a loss and expense. But there is no change in the grounds for loss and expense claims from the PSSCOC 2014 version. So while there are new grounds that are added to your EOT clause that we've looked at earlier, you have not had new grounds added to your loss and expense provision in clause 22. So what this means in summary is that even if you are able to prove that you can claim extension of time under your earlier clause 14.2, you may not be able to claim loss and expense arising from the same set of events unless they fall within clause 22.1. Next slide, please. So as I mentioned earlier, there are no changes to clause 22.1, save for the definition of loss and expense. So you will still have to comply with your notice requirements before you're entitled to claim loss and expense under clause 23. Next slide, please. And these are some of the grounds that we have looked at earlier in a fair amount of detail. And the conclusion is that if you are claiming for extension of time arising from a pandemic or epidemic, you may not be able to claim loss and expense, meaning you get time, but not money. Next slide, please. And just one thing that I would like to highlight, you may think, okay, if my contract doesn't allow me to claim for loss and expense, maybe I can still go for adjudication. But now, under the adjudication regime, it has been clarified pursuant to one of the new amendments that section 17(2)(a) of the SOP doesn't allow a contractor to claim for loss and expense claims unless you fall within one of the two exceptions. That is, if you show that there are documents showing that parties have agreed on the quantum of such claims, or such claim is supported by a certificate or document required by the contract. So the purpose of this amendment really is to make it harder for contractors and likewise for employers as well to put in complex claims for loss and expense, which are more suited for litigation or arbitration. Next slide, please. So I will pause here and pose a question to the audience. That is, do you think the current changes to the PSSCOC for variations, extensions of time, and loss and expense adequately address future episodes of pandemics and epidemics? Yes or no? And I will just give you a couple of minutes to deal with that question. All right, we have the poll results. Interesting stats. Almost 50% of the audience feel that the current changes are adequate. So that's an interesting insight. Let's just move on to the next half of the webinar. Next slide, please. So I now come to this topic of termination. Now, under the new PSSCOC, i.e. the 2020 version, you will see that clause 31.1 now specifies that unless such termination is prohibited by written law, the employer can actually terminate for the contractor's default. And clause 31.2 again specifies that no such sum will be due to the contractor unless of course until after the expiry of the defects liability period. So clause 31.2 in itself is a suspension clause. So it doesn't allow the contractor nor the employer to certify any monies after the contractor has been terminated for default. There is this period of suspension until, of course, after the defects liability period. Next slide, please. And if you look at clause 31.4, termination without default, it's quite different. It basically provides that the contractor can be certified payment for all work executed prior to the date of termination at the rates for the works that are set out in the contract, any loss and expense suffered by the contractor in connection with or as a consequence of the termination, and the SO shall expeditiously certify the amounts payable to the contractor under this clause, and the contractor shall provide all reasonable assistance to the SO. Next slide, please. So, as I mentioned earlier, clause 31.1, that's termination for default. You will have to now make sure that before you're terminating your contractor for default, that it is not prohibited by any written law for termination. So essentially, if you are unsure about whether you are terminating correctly or whether it's infringing any law, because at this point in time, the laws are constantly changing, especially with respect to the COVID-19 Act, you may want to check with your lawyers first before you issue a termination for default notice to your contractor for any works that they can't carry out. Next slide, please. And the key thing to recognize about termination for default and termination without default is this. So you may recall that earlier we looked at the termination for default clause 31.2. It quite clearly states that you may not certify any amounts to the contractor until after the expiry of the defects liability period and until the employer's cost has been certified. And you will also further note that the clause for termination for default actually doesn't contain any provisions for submitting any payment claims, immediately submitting payment claims after termination for default. And on top of that, there's already a suspension period. And that's important. Why? Because of this very recent case of Shimizu Corp versus Stargood. So what happened in this case is that the subcontractor was terminated for default, and the subcontractor continued to issue 2 payment claims immediately following the termination for default. And the Court of Appeal then held that the SOPA does not provide a statutory regime to progress payments, which is separate from a party's contractual entitlement to payment. So in short, if you are a contractor, you've been terminated for default, and you want to submit further payment claims, the contract itself must be worded in such a way which allows you to put in further payment claims, and that the certification process by the SO is preserved post-termination. So that's important. If you don't have such provisions in your contract, then you will not be able to make use of the adjudication regime. So you will see, this is a nice contrast, the termination for default provisions versus the termination without default provisions. You will see that there's a contrast, and the implication is important because of the Shimizu case. Next slide, please. The other big topic is on final completion. Now, this is important because maybe a number of works have come to an end just before the COVID-19 period. So let's look at the provisions here. Clause 32.1 of the PSSCOC 2020 version provides that the contractor may submit such monthly payment claims up to the SO's issuance of the interim final account. And then what happens in clause 34.1 is that the SO will only issue a final completion certificate at some point within 30 days after the expiry of the defects liability period. Next slide, please. So why are those provisions so important? Now we come to this case of Far East Square, again another Court of Appeal decision. What happened in this case was that the contractor submitted 18 payment claims after the final cert has been issued by the architect. And this is the SIA form, but we can still gather some lessons, even though this case was based on the SIA form. And what happened was that the Court of Appeal then decided that the contractor cannot, after the issuance of the final certificate, continue to put in payment claims. Because what happened is that the architect becomes functus official and no longer has the power to issue payment certificates. So as the architect's certificate is a condition precedent to the contractor's right to receive a progress payment, any payment claim that is submitted by the contractor after the final certificate would be invalid. Next slide, please. So how does that transpose to the PSSCOC? Now, if we look at the PSSCOC, the provisions are obviously quite different from the SIA form. 32.4 of the PSSCOC provides for within 90 days from the substantial completion, you issue as contractor a final payment claim. And then within 21 days, the SO shall then provide an interim final account. And just moving along, if you go to somewhere in the middle of the slide, you will see that it is only after 30 days of acceptance or deemed acceptance by the contractor of the final account or of the amendment of the final account, right, around that time, then the SO shall issue a final account certificate. And this is after 30 days after the DLP period. So what I'm saying here is that there is a period of limbo between the issuance of the interim final account and the actual issuance of the final account certificate. Can the contractor actually put in further payment claims and make use of the adjudication regime? Now, on one view, one may argue that clause 32.5 quite clearly states that the SO can issue an interim final account, and the earlier provision we've looked at has also stated that the payment claims can continue to be submitted up until the SO's issuance of the interim final account. But that on that particular view, it is silent on one weakness of that particular view is that it is silent on whether it prohibits further payment claims after that period. So it's a provision that says that you can submit up to your interim final account, but it doesn't say whether it prohibits any further submission after the interim final account. On another view, if you look at the Far East Square decision and you apply the same sort of principles that the Court of Appeal has adopted, then it may be that the payment claims cannot be submitted only at the point of the final account certificate. So it's only at that point where the SO will be functus official and will no longer have the power to issue a payment response. So this issue is still up for debate. There's still no authority on this point, and also no clarity from the current PSSCOC 2020 version because it's not been amended. Next slide, please. Now I come to another important topic of liquidated damages. Now this topic, again, is another big topic that's weighing on many contractors' minds during this COVID-19 period. Let's just look at the provision, clause 16.1 of the PSSCOC 2020 version. It says here, if the works shall not have been substantially completed within time or any extended time, then liquidated damages can be calculated based on the rate or the rates stated in the appendix. And that could be awarded to the employer. Next slide, please. So some observations. The first observation is that there's no change from the PSSCOC 2014 version. But what you will have to bear in mind is that under the COVID-19 Temporary Measures Act, there is a provision that provides that once a notification is lodged under the COVID-19 Act, then in terms of calculating your liquidated damages for that period of time, you will not be able to use that period of relief towards calculating your liquidated damages. In short, you will have to minus out the period of relief in which a contractor has lodged a notification on, and minus that out in terms of calculating liquidated damages. Now, the other thing that is important is, again, it relates to the adjudication regime. You may recall we've looked at section 17(2)(a) of the SOPA. That provision very clearly states that any sort of loss, damage, expense cannot be considered by the adjudicator unless there are documents showing that parties have agreed the quantum of liquidated damages, or there is a certificate or a document that is required to be issued under the contract. So if you look at the PSSCOC clause 16 that we've just looked at, does that allow you to actually claim for loss, damage, or expense under the adjudication regime? On one view, some people may say that it's good enough. It's good enough because there is a loose provision that somehow deals with liquidated damages. And it's also good enough because at least there is liquidated damages rates that are listed. And so that would cover the aspect of quantum of liquidated damages. But on another view, some may say, look, the current PSSCOC as drafted is not adequate, because if you were to compare that with clause 24(2) of the SIA conditions, there is a specific provision in the SIA conditions that allows you to issue a delay cert. But here in the PSSCOC, there isn't such a provision. It only allows the SO to certify extension of time. And also, it's not good enough to just have an agreement before the occurrence of the actual delay event. You must have a specific agreement after the delay event. And not only that, you also must have a specific agreement on the quantum. And quantum here means not just rates, but on the number of days of liquidated damages. So unfortunately, the current PSSCOC 2020 hasn't addressed this issue specifically, but we will await to see if there are further changes made to the PSSCOC. Next slide, please. I come to the final topic on service methods. Under the new PSSCOC 2020, you will now see that in clause 37.2, the contractor shall provide in his form of tender not just an address, but if you look at the part that's bold, the contractor will also have to provide his email address and fax number. Okay, and just moving down to the middle of the slide, you will see that the contractor now can send notices by a number of means, not just by ordinary post. He can also send it by email or by fax. Next slide, please. So a number of observations on the PSSCOC 2020 version. As I mentioned earlier, the contractor must now provide email address and fax number for service of the documents. Of course, there is an exception if you are submitting certificates and notices under clause 31 for termination, which is a very serious provision to utilize. Or if you are trying to settle your disputes pursuant to clause 35, then those sort of notices, you cannot just simply use email as a valid method of service. As another observation, what is interesting is that they have now removed cable and telex. I remember a couple of months back, I was just looking at this provision and thinking to myself, what exactly is cable and telex? Because these are modes of communication which I think most people do not use anymore. So it's a positive change in terms of the PSSCOC. As I mentioned earlier, the contractor can now use email, posts, or fax. And the new provisions in the PSSCOC 2020 now clarifies that if you are doing it by way of post, then 4th working day after posting, that's considered when the notice is received. And if it's done by email, then it is at the time of entering into the information system. That's considered when the email is received. And if it's by fax, then at the time of transmission, but of course subject to the fax machine actually providing a notification of successful transmission. Next slide, please. A number of points to note about email, using email to submit any sort of notices. That is, it doesn't matter when, if the email may not even be read. Or you also need to ensure that your email address is one which is permanent, you know, and one that someone will be responsible for checking every day, because it's considered to be deemed received at the point when it's transmitted into the information system. So if you don't read it, then that's going to be a problem, because, for instance, you may even forget to put in your payment response just because a payment claim has been submitted by way of email. So overall, for this particular provision, clause 37, I think it's a positive change because it's generally more in line with the electronic means of communication in a post-COVID-19 world. And importantly, it brings the PSSCOC in line with the amended Section 37 of the SOPA, which also now provides for service via email. Next slide, please. So I have one final question, that is, should the adjudication regime be limited to only damage, loss or expense claims where there are documents showing that parties have agreed on the quantum, or certificate documents required to be issued under the contract? So this is a hot topic for debate. Not everyone agrees with the current amendments to the to the SOP Act, and how that interacts with the number of standard forms that are widely used in Singapore. So let's put it to a vote. Okay, again, interesting results. It's quite evenly queued. Almost about 50% think that the current regime is great. Of course, the other half don't quite agree, but that's interesting to know. And with that, I've come to the end of my webinar. And thank you very much for taking the time to attend today's webinar. And I would also like to thank SIBL for taking the time to host this and giving me the opportunity to speak here. Thank you.
Thank you, Ms. Danna, for sharing a very insightful presentation with us. So now, ladies and gentlemen, let us jump into the Q&A session. The first questions that we have here is, hi Danna, with regards to EOT, if the client stops work due to change in the project management personnel and restart weeks later, can the contractor claim for EOT? And if yes, under which clause? Thank you.
Okay, so the question is, if the contractor is told to stop works under a PSSCOC contract form, can the contractor claim for EOT, and under which clause? Did I get the question right?
Yes.
Okay, right. So maybe it'll be helpful to just look back on the slides that we have, that I have earlier. Sorry, if you may just upload the slides. I think it's helpful for the audience to look at the provisions again.
Okay, we will share the slide again. Jessica, can you please share the slide again? Sorry, just 1 second. Jessica is pulling out the slides for
Sure.
everyone.
Okay, so while you're at it, maybe I will just explain. So under the extension of time clause, clause 22, I'm assuming that you are using the clause 14.2 of the PSSCOC 2014 version. So under the 2014 version, it's quite limited. You will have to show that whatever event that you are told to stop works for is beyond the, it's a force majeure event. So arguably your stop works order could potentially fall within that ground. Um, of course, I do not know if the specific reason for the stop works during that time frame is a result of, say, insufficient workers, and then there is an embargo or a specific quarantine order, then that could potentially also be a ground. The more common ground in which contractors will probably want to consider would be if you are complying with any law, regulation, or public authority, right? That could potentially also be a ground. I believe the clause 14.2 also has a suspension order as a ground. So if that is, I just need to quickly check that, I believe that is the case, then that could also be a ground in which you can rely on. But more importantly, if you feel that you are not able to meet certain timelines under the contract, then you may want to consider the COVID-19 Act, lodging a notification, because you may recall, as I mentioned earlier, that would help with your liquidated damages assessment, because the SO will not be able to consider the time frame, the relief period towards the calculation of liquidated damages. So that would actually help in terms of your case as well.
Okay, so sorry, we actually have the slides on. Do you want us to go to the slides?
Okay, maybe just for the audience benefit, we will just move to the extension of time provision.
Okay, extension of time, Jessica, please. Number 3. Would it be this one?
Yes. So
Okay.
these were some of the factors that I mentioned before. So you will have to try to fit your case within one or more of these grounds. Of course, currently, if you're not using the 2020 version, then Q is not available to you. And then A is not defined as such currently as well. But yeah, so these are some of the grounds that you can try to use for purposes of putting forward your case to the SO.
Okay, so right now we will have a look at question number 2. Can COVID-19 be considered as force majeure?
Okay, thank you. So I would argue that it is a force majeure event, especially since a number of, I mean, bearing in mind that it's very widespread, it's unprecedented, a number of regulations as well as restrictions have been imposed, both outside of Singapore as well as within Singapore. So I think it is more likely than not that it is a force majeure event. But of course, that said, it really depends on what exactly the work that you are not able to do relates to. I mean, if it's a small part of the works and it's just because it's more expensive, then that arguably may not be a force majeure event. So it really depends on what is it that you are not able to do. What exactly is that contractual obligation that you are not able to undertake under the contract? But generally, my personal view is that yes, it would be more likely than not a force majeure event.
Okay, so I think we will have to, because we are running short of time, we will have to wrap the session today. And for those unanswered questions, we will reach out to other audience separately.
Okay.
And once again, we want to thank Ms. Danna for this very informative session. We hope all of you have enjoyed the session brought to you by Singapore Institute of Building Limited. And the next webinar session is at 2 o'clock. Hear from FinaCAD on how to tackle the biggest cause of project delays. At the same time, you may also spend some time visiting the exhibition hall where 100 virtual booths are on exhibit. Thank you once again, Ms. Danna, and thank you everyone for joining us today. Stay safe.